Meeting of the Board of Appeals for March 19th, beginning at 7 p.m. Have those who would like to speak signed in? Pardon? Nobody signed in. Yes, you should sign in if you'd like to present, including the applicant. And Jack, you're Jack. If you'd like to sign in or make any statements during the meeting, we should have you sign in. All right, thank you, Jennifer. All right, so what we will do first is review and approve the minutes from February 6th. Were there any questions about the minutes?
No questions, Dan.
All right, do I hear a motion to approve the minutes of February 6, 2024 as written?
Motion to approve.
All right, motion to approve by Wayne Slaughter and seconded by Scott Frager. All right, all in favor signify by saying aye.
Aye.
Aye. All right, before we get into swearing the witnesses, one of our members, Scott, brought some thoughts forward, and he would like to, and I would like to discuss them and make sure that we're all going in the same direction. This does have a little bit to do with the purpose of the Board of Appeals and our role. So I think it's important to lay it all out and get it understood by all. So Scott, I could go through this. I did take notes on each of the points, but I'd like you to give a summary of what your concerns are, kind of in a abbreviated format, the main concerns and what you'd like answered.
Very good. And so I think the first thing that should be said is this has the appeal, the people that submitted the appeal, the insurance company didn't do anything wrong. Okay, so this has nothing to do with that side of the business. This has more to do with the fact that the Board of Appeals is a legislative body of the town of Emmitsburg government, along with the Planning Commission, the Board of Commissioners, and so on. Your partner, Clark, last week provided us some very good insight that we needed to hear. And if I quote, it began with, the legislative body, the commissioners, have already determined the issue at hand to be a permitted use in the IP zone. And that certainly would seem to be an accurate statement, but you'd have to assume, I think, that their support is the result of, we have a municipal code that they enforce, and the municipal code has functional requirements that would indicate that this is okay, that the appeal is legitimate.
We need to make sure we're using the correct words, the special exception request.
Please help me.
In this one is the special exception request.
Yes.
Okay, good.
And so if I were to get right to the point, okay? One of the things that I do in preparation with a package like this is talk to people in Emmitsburg. I don't go into any details about the case. I don't talk about being on the Board of Appeals, but I simply ask the question, is this good for the town? And one of the things that came up, and it happened to have come up with 2 members of the Board of Commissioners, is they didn't know about this. And when we spoke about it, the issue also came up. What is the term of this appeal? The appeal was submitted legitimately. It appears that it is something that based on what we were told is the law that we should concern ourselves with. My concern is not listed there, but my concern is they have a lease, it gets approved. What happens if they want a second lease or a third lease? Is it automatically approved? Do they have to resubmit another appeal?
Another request for special exception.
Another, I'm sorry,
That's okay.
request for special exception. And so the statement was made to me, then why do we have an industrial park? Because the thing that needs to be said is the partner of the insurance company, and it's not clear to me whether or not they're sharing 2A, that the owner of the building has submitted a permit to the city of Frederick to separate this into 2 units, 2A north, 2A south now, okay? Is that permanent? Are there walls around it? They're separate legal entities. Are they coexisting? Is one associated with the other as a subleaser? None of that is clear to me,
Okay,
okay?
okay.
And it could be my own ignorance. There could be something that you guys know that is not clear to me, but the reason I'm bringing it up is the most important part of our legislative branch, in my mind, is the Board of Commissioners. And 2 out of the 5, I didn't talk to any more than 2. I wasn't sure I needed to, and I don't even know that it would be appropriate. They just happened to be available, okay? But they didn't know anything about this, and one of them brought up these issues.
Let me know when you'd like me to jump in.
How about
We'd like who to jump in? Did you, okay. First of all, we are not a legislative body, is my understanding. We are a judicial body in the town, right?
Quasi judicial administrative. Yeah.
Okay, good. So that's the first thing. I'm not sure that the use permitted in the IP zone, this is a use that is permitted in the code. So I'm not sure that, and that was what Leslie was saying here in the first quote, the legislative body have already determined it to be a permitted use. So it's in the code as permitted in B1. So I'm not sure if some of the questions have any merit to our determination tonight.
I agree.
But I'm glad you're bringing them up. And Clark, if you could
Sure.
answer some of these.
Just to elaborate on that point a little bit. I mean, fundamentally, what the Board of Appeals is charged with doing is taking the criteria that the Board of Commissioners has already approved by adopting the zoning ordinance. And as part of that zoning ordinance, it currently says in the IP zone that certain uses are permitted subject to review by special exception, which is what we're going to engage in now and what you engaged in the last time you met as well. So the Board of Commissioners has already spoken on this issue as to whether or not this is permitted. Your job then is to look at this case, look at the criteria that the Board of Commissioners has provided you in the code, and apply that criteria faithfully. So while I certainly understand, and I think it is a good and noble question to sort of ask, is this good for the town? But I think what I would maybe frame this as is a much more limited inquiry that your board is to make. It really is, these are the standards. This is the application that we're presented. Does the application meet these standards? And now, to the extent that the commissioners look at this and say, well, maybe this isn't what we intended, or maybe, that process gets changed by the Planning Commission and the Board of Commissioners making changes to the code itself. For example, if for some reason they think that this type of use is no longer acceptable or not a good idea for this zone, they change the code to say that. But that's not the determination that gets made during these meetings. Is that helpful?
And the Board of Commissioners would be, this is publicly notified. So the Board of Commissioners would be notified of this if they looked at the newspaper or asked the planner, right? It's not something that's hidden. It was advertised 30 days ago. So the Board of Commissioners could find out about it. I think maybe what you were looking at is the fence issue, where it actually did create, what we were doing created the need for the Board of Commissioners to go back and look at the code and make changes to the code that made sense for the whole town. In this case, I don't see that there's that concern, because this is just a special exception use. So
there are two sidebars then, and you hit on one of them, okay? And it wasn't the fence, it was the definition of a
of a secondary front yard, right?
Okay, and the
right.
fence just complicated things.
Right.
The
Right.
other one is that 2A is being occupied as the result of the Board of Appeals determination last month.
Mhm. Mhm.
And that was made clear to be a temporary situation. There was no time limit put on it, but it was clear that it was temporary because the major objective was to build a private school that would serve Emmitsburg and any parts of the local community.
Mhm.
This is not temporary. This is a business that, why would they want to move once this is approved? And so that is the job, I guess, of the Board of Appeals. That's what we're here to determine. And, it was very clear that, is there any particularly adverse impact on the surrounding neighborhood if we approve this? Okay, certainly there's not. Well, I would surmise that there is not. And is it different from the use anywhere else in the IP zone if it were to be approved? And the answer to that is clear.
Mhm.
But it's a permanent situation potentially, unless, what is the follow-on application of a determination made tonight? Is it for this business in this location forever?
Yes, until
Mhm.
until someone essentially changes the use and files for a new permit reflecting a different use, this special exception would apply. I think in the case with the school, actually the reason that the temporary language got included in there is I think they even included that on their own application. So that was sort of a self-imposed condition that they took on themselves.
They did.
Um,
This is the finding. Until December 2024.
Right. So that's why
They
that
have
one was
put that in.
temporary, but the standard operating procedure is when you grant a special exception, it is granted. And again, that's part of the consideration that goes into when the zoning ordinance is drafted or potentially amended. What are we going to say is something that we are comfortable with there being a special exception in this zone for? And as currently written, the determination is that, you know, what's in there now, that's what the town is comfortable with until it's changed.
And so what I've learned from this, and please correct me if I learned incorrectly, is if this appeal meets the law, the ordinance as it is written today, it doesn't necessarily matter who and how well they were briefed. If they have a problem with it, it's got to be changed for future applications.
So if the they there you're referring to is the Board of Commissioners, then yes. There's no requirement that they be briefed. If I would say if they're, you know, if people see the board your board faithfully applying the code and granting special exceptions that have been, you know, permitted by the code, and they say, I don't like that, and they talk to the commissioners about it, and the commissioners agree, and that's kind of how that goes. And I mean, functionally speaking, the process of amending the zoning ordinance takes time. I believe it takes at least 60 days because it needs to go to the planning commission first and then to the commissioners. So functionally speaking, even if, you know, the commissioners learned of a particular applicant and they thought, oh, we don't like that, they wouldn't be able to change the code in advance of one particular application. I mean, I think that might even have some additional issues with it, just from a, I don't, due process might be an exaggeration, but there could be some problems with changing things in direct response to one particular applicant. But yeah, the process for change is for the future. It's not for the now. I hope that was helpful.
Was that helpful?
It was. My mind is not letting go of the fact that the instance that I brought up was the second front yard, and the code was changed, and you hit the nail pretty much on the head. I think it took about 60 days, but it was applied immediately. And those are the kinds of things in terms of due process that maybe it's not supposed to happen that way, but it's nice to think that the town can respond that quickly for a noted and worthwhile cause.
Right. And that was something, that issue was something that was going to come up again and again because of building major thoroughfares through developments that we hadn't really thought of before when the planning commission was looking at the codes and the Board of Commissioners were taking their recommendations to adopt or reject certain things in the code. So that was a new situation that had been brought about because of the way the town is being designed now. So it made sense to look at it in that case. I would submit that I'm not sure that a special use request would rise to the level of having somebody look at the code and saying, oh my gosh, we got to make sure no more insurance companies can go in the IP zone. You know, I'm just not sure that it rises to that level because it's probably not going to affect a lot of other people. So, but I want to make sure that we address the concerns that you bring up. I'm glad you bring them up. We do need to cover them in public due to the Open Meetings Act. So ex parte communications are one of the things that that are not allowed in our Board of Appeals rules and procedures. I think we all got copies of those last time, right? That's on the last section of that rules of procedures. So you did bring up a good point though, and Brian had brought this up too. We do need to change the findings and decision on case 2401 to note that that's A2 South, since this one will be A2 North. So we do need to bring that up. And those are two separate businesses with separate special use exceptions. So we have to look at them separately. The owners of the property actually have to sign off on the application. As you saw, those are the owners of the property and they have to list it there. And that but you read through all this, right? Did you have any questions about this?
No, the case does seem fairly straightforward.
Right.
And I understand, and thank you, Clark, for the lesson. You know, that the only thing that I would add is in the world that I've grown up with or in, and perhaps it doesn't apply here, managing a town is a system and it requires a bunch of different parts. And in the engineering world, System Engineering 101 identifies functional requirements and non-functional requirements. Non-functional requirements come up when what needs to happen to be consistent with the law is in black and white, and it can't be changed without your term, due process. Non-functional requirements are what are developed so that you can objectively determine whether or not the requirement can be measured and proven to be completed. And so for me, the element of time was important. But what I heard loud and clear, Clark, is it is customary and normal that when a Board of Appeals makes a determination, it is pretty much forever until there are mitigating circumstances that change things.
Right. There are a lot of things that can happen in between now and forever, but yes.
Absolutely. And I'm not trying to, you know, overstate that. So,
I hear you loud and clear.
all right. Thank you.
Okay.
It's different and I learned. So all of you forgive my ignorance.
No, it's important to ask these kind of things and bring them up. And the fact that the Board of Commissioners do have access to the calendar and would have all the notes about this hearing, right? And could certainly come and speak if they wanted to about a certain issue and then discuss whether or not they wanted to bring it up. Wayne, did you have any questions or anything you'd like to add?
No further comments. No.
Okay, good. Is it all right if we move
You're
forward?
asking me.
No, I want to
Yes,
make
ma'am.
sure that, I want to make sure that you're comfortable with what we've discussed and the answers that we've gotten.
Comfortable is relative. I am satisfied that I understand the law and that's what matters.
Okay, all right, fantastic. Well, then we will move on and we appreciate your answering the questions, Clark.
That's my pleasure.
All right. And now I am looking for, yes, okay. I'm looking for my agenda, which I have gotten messed up with the, all right, here we are. We've already reviewed and approved the minutes, so let's swear the witnesses in. Witnesses, if you could stand, please. That's Jennifer, Clark, Sheila. Raise your right hand. Do you solemnly swear or affirm under the penalties of perjuries that the responses given and the statements made by you in these proceedings will be the whole truth and nothing but the truth? If so, state I do. All right, please note that all three witnesses stated I do. All right, we have no old business, or we kind of went over it during that part, but I wanted to make sure we got that handled first. So the new business is the special exception request for 17750 Creamery Road, known as 2A North, to distinguish it from the Chesterton Academy, which we looked at last month. All right, and the applicant is Jennifer Warden. She is seeking a special exception request to ask us to allow specific use for this property for an insurance business. She has filled out the application and expressed her understandings of the conditions that will meet this request as outlined in the code for a specific use. All right, so presentation of case by the staff.
So good evening. You covered part of what I was gonna say, but I do wanna point out the assessments the staff has made. So the unit in question is already home to a similar type of use, and facilities for water, sewer, and trash management have already been established. The nature of the operation as described by the applicant will not impact the peaceful enjoyment of its surrounding residents. No historical or cultural landmarks will be affected. Emissions as described in section 17.12.060B12 are not expected from this type of use. So taking all these into consideration, staff concludes that the office for an insurance agency is a compatible use with its surroundings, and the special exception request should be approved.
All right, thank you very much, Najila. Jennifer, would you like to add anything else to the statements? I think your application was pretty complete. All right, is there any public testimony in support or opposition to the applicant? Since Jennifer was the applicant, was the only person who signed up to speak, I would assume not. Any changes? All right. Board discussion.
I've said everything that I'm aware of. And Jennifer, I would like to tell you personally that I don't see where your insurance company will have any adverse impact on the surrounding neighborhood or because of this particular location. So I appreciate the learning opportunity.
All right. Wayne, would you like to add any comments or ask any questions?
No, I have no further comments.
Okay. Do we have a motion to accept the application for a special exception from the Board of Appeals for an insurance agency in this location?
Motion to accept.
All right, motion to accept made by Wayne Slaughter. And what we'll do is describe it. We can actually use the findings and decision from the last case and just spell all this out. That's why I brought that along. I think it'll be helpful. Use the same language as in the Chesterton Academy and find that the proposed use of unit 2A, this one's north or south? Forget, north,
North.
right? North, okay. does not have a significant adverse impact on the surrounding neighborhood compared to other areas in the zone. And then there are 4 conditions that would be met, and those can just be copied from the previous findings. So we have a motion by Wayne Slaughter.
Can I be annoying and ask you to actually read those
Sure.
findings just for the sake of having a record?
Having the record of it. Okay. So the motion was, correct, that the proposed use of unit 2A North at the location does not have a significant adverse impact on the surrounding neighborhood compared to other areas in the zone. The evaluation is based on the following criteria based on code 17.12.060, which is the special exceptions. The proposed use of the facility will not necessitate the creation of a new sewer, water, or trash collection infrastructure, as these utilities are already in place. The applicant asserted that fire safety measures, including smoke detectors, illuminated exit signs, and fire extinguishers, will be implemented as required by the state. Due to the size of the office and staff, residential zones and other types of structures in the vicinity are not impacted. Traffic conditions are not to be affected based on the staff and the business owners' trips to the proposed location, and adequate parking described in the applicant's request and supplemental submission. Do you need me to read anything else about the board action? Oh, we haven't called for a vote.
Right.
Right. All right, so we have a motion made by Wayne Slaughter and a second by Scott Frager.
It's not a discretionary matter.
Right. Clark,
Can-
would you
Can I,
have any questions?
can I,
Yes.
can I get you to add just a little bit more?
Mhm.
I think your conclusions are solid, but if we could just, for the sake again of the record, as we did with the previous ruling, some findings of facts with respect to this property, because they are slightly different. So if we could just, based on the
Alright.
application,
So the factual findings
Yes.
of the board are as follows. Per 17.24.030 of the town code, all uses permitted in the B2 district will require a Board of Appeals approval. Per 17.20.020 and 17.20.030, insurance offices are allowed in the B1 and B2 districts. Based on the description of operations provided by the applicant, there are no factors contributing to population growth based on the nature of the use as an insurance office. The chosen location will accommodate at this point 1 office manager or owner and 1 staff person, with the anticipated addition of 1 more staff person if possible. Water, sewer, and trash collection are already established at this property, therefore will not necessitate installation of any new infrastructure. The site is approximately 0.2 miles away from the nearest residential zone. Traffic conditions are projected to remain unchanged based on the applicant's description of staff and owner usage of the parking lot. Emissions as described in 17.12.060 B, subpoint B and 12 are not expected from the facility's operation. The applicant asserts that the location of an insurance agency will not diminish property values. Those are the findings of fact. And then we do find that the proposed use does not have a significant adverse impact. And then the statements that I read before. So sorry, I forgot the findings of fact
that's okay.
up until that point. All in favor of the motion signify by saying aye.
Aye.
Aye. The ayes have it. I did hear you say aye, right? Aye, Okay, good. Thank you. All three members voted in the affirmative. Pending any further discussion?
No further discussion.
All right, do I hear a motion for adjournment?
Motion to adjourn.
All right, motion made by Wayne Slaughter,
I second.
seconded by Scott Frager at 7:35. Motion is adjourned, the meeting is adjourned. Thank you.